Hello everyone. So we were in week 2 of conflict management through mediation course and discussing on differences between the various types of alternative dispute redressal mechanism. In today's session, we will be discussing on the difference between the conciliation and mediation. To understand the difference between conciliation and mediation, it is very much necessary to understand conciliation, as we have already understood what are the basic features of mediation and what is meant by mediation. So conciliation, it is unlike mediation, it is also a voluntary process wherein a neutral third party assists the parties to resolve the dispute, and that neutral third party we call him as a conciliator. So conciliation involves, like, it is assisted negotiation among the parties wherein conciliator provides the suggestions or generate options before the parties. So the options which are provided by the conciliator are not binding. So it is up to the party whether to accept it or to reject it. And he does not decide for the parties. Only he supports the parties by means of generating options. Even his function is to break a deadlock and encourage the parties to reach at an amicable settlement. So basically, the process of mediation is, even it is voluntary in process, and even the conciliation proceeding is also a voluntary process. The process of conciliation is very clear, like meet the parties meet the conciliator, the parties make the statement before the conciliator as to their dispute. Under certain circumstances, the conciliator provides the suggestion which are non-binding, but the party may consider the suggestion given by the conciliator and arrives at an amicable settlement. The whole process of this, we call it as a conciliation process. There are various silent features of conciliation. So conciliation proceedings are private in nature. Even how the mediation proceedings are in private, similarly, the conciliation proceedings are private in nature. It is informal because whatever the discussion that take place, the discussion will take place in an informal mechanism. It is risk-free because there is no binding nature on the parties, being its voluntariness. Even it is confidential because whatever that has been discussed during the conciliation proceeding cannot be used before court of law or before any arbitration proceedings. It's a non-binding process because conciliator cannot impose or cannot adjudicate the matter like that of court. The conciliator can only propose the options to the parties to resolve their dispute. And it is, the conciliation process is been associated by the neutral third party, we call him as a conciliator, and he assists to negotiate the parties among themselves to resolve at an amicable settlement. And whatever the outcome that has been reached by the parties with the help of the options that has been generated by conciliator or the suggestion that has been generated by the conciliator, so they reach at an amicable settlement, draws an agreement, and that agreement is binding and enforceable. So this all is because the Arbitration and Conciliation Act of 1996 has laid down the procedure of conciliation, and chapter and section 61 to 81 of the Arbitration and Conciliation Act discusses about the conciliation proceedings. Even there are various other legislations which recognize conciliation in India, specifically the Industrial Dispute Act of 1947, wherein section 4 clause 1 and section 12 of the act provides that the government should have a empaneled conciliators. So the government should have a empaneled conciliator to resolve the industrial disputes among the government or dispute relating to the any industrial dispute that can be resolved before any industrial tribunals as well. As we all know, all the ADR mechanisms are well recognized within the ambit of Civil Procedure Code 1908 through section 89. Even the Family Courts Act of 1984, the very object of the Family Courts Act provides that the family dispute should be resolved in a speedier manner and they can use a conciliation as a means to resolve that dispute. Even the Legal Service Authority Act of 1987, wherein Chapter 6A and Section 4 Clause F recognizes conciliation as a means for resolution of disputes. So under Legal Service Authorities Act 1987, we have in-depthly discussed in the next session of this course. And the Legal Service Authority Act 1987, which has empowered to establish the authorities and to hold a Lok Adalat, wherein the permanent Lok Adalat, which is established under the Act, resolves the dispute by means of conciliation. Even the Companies Act of 2013, through section 442, empowers the central government or states that the central government shall maintain the list of experts to be called as mediation or conciliation to resolve the dispute through the proceeding before the central government or tribunal or appellate tribunal. So these all legislations have well recognized the conciliation in India. To coming to the specific aspect of conciliation under the Arbitration and Conciliation Act of 1996, the scope of conciliation is well defined under section 61 of the Arbitration and Conciliation Act. So here, section 61 states that all disputes arising out of legal relationship, whether it may be contractual or it may not be a contractual relation, all such disputes can be resolved through conciliation proceedings. So here are some of the cases that are suitable for conciliation. If there is any commercial transaction dispute, the dispute of a personal injury, dispute relating to the constructions of buildings, the dispute relating to workman compensation, dispute relating to employment, dispute relating to labors or community relations, or any matters which not involve a complex procedure or evidentiary issues, such matters can be resolved through conciliation. So basically the Act also provides the procedure for conciliation as to who should initiate the conciliation proceedings with section 62-63, wherein the parties have given the power to appoint the conciliator. They may appoint one conciliator or two or more. It depends on the parties how many conciliators they wanted to appoint. In case if they are appointing one conciliator, then both parties mutually understand, agree and appoint a conciliator. In case if the parties want to appoint two mediators, then each party should appoint one mediator each, and in case if they want to appoint three mediators, then each party should appoint one conciliator each and the third conciliator will be on a mutual understanding among the parties. So this is how the conciliator will be appointed, and that has been well derived under the Arbitration and Conciliation Act. Coming to the next part, what would be the role of conciliator? See, the conciliator has been appointed for resolution of dispute. Then what is the role of the conciliator? So the conciliator should be independent, he should be impartial and assist the parties independently and in an impartial manner to arrive at an amicable settlement. The conciliator shall guide by the principles of objectivity, fairness and justice. The conciliator should give a due consideration to the rights and obligations of the parties, the usage of trade concern, the circumstances surrounding to the disputes, and the previous business practices that were being followed by the parties. The conciliator may conduct the proceedings according to the self-mode procedure, but he shall give due regard to the wishes of the parties, request of the parties to give oral hearing, and need for speedy settlement of disputes. So the conciliator may, at any stage of the conciliation, may propose settlements, like he may come up with the options to resolve, or he may provide suggestions to resolve the dispute. It need not be in a writing or nor supported by reasons. He is just required to, he may generate the options. It may be in writing or it may not be. So he may give reasons for such options which he has generated, he may not be. But the thing is, like, it is being a voluntary nature, the parties have the discretionary power whether to hear such suggestions, whether to adopt that suggestion which has been given by the conciliator. It is up to the parties discretionary. Even section 69 denotes about the communication between the parties and a conciliator. So, under certain circumstances, the conciliator may communicate with the parties either by inviting them to meet together or separately, or he may also communicate with the parties by means of oral or in writing as well. The parties shall meet the conciliator at the place determined by the conciliator after consultation with the parties and at a place agreed by the parties. Basically, in most of the circumstances, the parties fix the place where they will be meeting, and even it can be determined with the consent of the conciliator or vice versa. The section 670 of the Act provides for what are the circumstances under which the disclosure of information, whether whatever that has been discussed in a conciliation proceedings, whether that can be disclosed. So basically, the party, whatever the discussion that has been taken place during the conciliation proceedings cannot be used as evidences or witnesses before any court of law. It cannot be used in arbitration proceedings as well. So the substance, even in case of the disclosure of information with relation to parties' discussion, like say for example, a party discloses some information directly to the conciliator, whether such information can a conciliator transfer that to the other party. The substance of information received by a conciliator from one party has to be disclosed to the other party. On such a disclosure, the other party may provide explanation thereto. If a party who has shared that information rejects or requests the conciliator to keep it secret, under that circumstances, the conciliator should not disclose such information to the other party. So this is how the confidentiality is been maintained amongst the parties as well, and that is where we call it as a private one. The conciliation, the feature of conciliation is private, so that's why we discussed that in the first slide. Even the section 75 discloses about the confidentiality, that is, a conciliator and parties are duty bound to maintain the confidentiality of proceedings of conciliation. Even I was discussing when I was started with the discussion of section 70 that whatever the discussion that has been taken place cannot be used as a witness before any court or before any adjudication process. So admissibility of evidence in other proceedings, that is, the information collected during the conciliation proceedings cannot be used as an evidence in court of proceedings. Party cannot rely or introduce the views expressed or suggestions made during the process of the conciliation. The admission by the parties, the proposal made by the conciliator, the fact that other party was willing to accept this can not be also be used as a witness before any court of law. So the conciliation settlement, what would be the status of conciliation settlement? If the party reaches to an amicable settlement, the parties, with the help of conciliator, draws an agreement, signs on the agreement, and each party, based on the suggestion they have made, the agreement will be drawn. And the agreement drawn, that the parties will sign to that, even the conciliator will sign that, and the settlement agreement will be reached. If the conciliator finds that there exists an element of settlement likely to be accepted by the parties, he formulates, like he draws the terms possible settlement and give them the parties for observation. On receipt of the terms, the parties may submit their observation. The conciliator, taking into consideration of observation of the parties, reformulates the terms of settlement, and if the parties reach an agreement, then the parties may request the conciliator to draw a settlement agreement and request the conciliator to help them to draw settlement agreement as well. When the settlement agreement is drawn by the parties, they both will be signing on that. Even the conciliator will sign on that agreement. Once the agreement has been settled, then the settlement agreement shall have the same status that of an award passed in accordance with the agreed terms under section 30. That is, the settlement agreement which has been entered by the parties in a conciliation proceedings will have the same power as that of an arbitral award passed on agreed terms. Consequently, it also enjoys the status of decree of the court. So whatever we have discussed, so here I have put it in a pictorial form, that is the conciliation. The conciliation request will be made by the parties, by party 1, by sending a request or an invitation to resolve the dispute to the other party by means of conciliation proceedings. The invitation should also mention the subject matter of the dispute. When the invitation is accepted by the other party in a written form, it is considered as a conciliation is commenced. Once the conciliation is commenced, both the parties on a mutual understanding may appoint one mediator, or they may appoint a conciliator. They may appoint a conciliator. Two conciliators may also be appointed based on each one by the parties. Each party will come and select the place with the discussion with the conciliator. The parties select the place of conciliation. The parties sits together for a conciliation along with the conciliator, wherein the conciliator may request the party to present their dispute. It may be in writing, it may be in oral, and the conciliator may request each party to give the copy of such statement to the other party as well. Then the discussion will take place at the place where they have set, and the conciliator may conduct the proceeding according to the self-made procedure. So, or either on the wish of the parties, the procedure may be followed. So, in that case, during the discussions, the conciliator may propose the settlement. Once the party agrees to such settlements, then the settlement agreement will be drawn, and such settlement agreement will be binding in nature as per section 30, and it will be considered as an arbitral award, which will be subsequently considered as a decree of the court. Now we have understood the various features of conciliation. Now let us have discussed about the similarities between the mediation and conciliation, which is the object of this session. See, there are various similarities between the mediation and conciliation. When we compare these both mediation and conciliation are non-adjudicatory process. Because adjudicatory process is because adjudicatory process means the neutral party decides the matter, whereas in case of mediation and even conciliation, there won't be any decision at all. So it is a party-centric process wherein party themselves reach at an amicable settlement. In case of mediation, the mediator roles the play of facilitator. Even in case of conciliation, the conciliator plays a role of facilitator. Only difference between the mediation and conciliation, while playing the role of facilitator, like the conciliation may propose suggestion, whereas in mediator cannot do so. Even in case of mediation and conciliation, it is a voluntary process. A voluntary process is because at any time, if the parties feel that the matter cannot be settled through mediation, they are free to quit either in case of mediation, they can quit mediation. In case of conciliation, they can quit conciliation proceedings. In case of mediation, the third neutral party call him as a mediator. In conciliation, we call him as a conciliator. In both the cases, the parties can take the help of lawyers for suggesting measures. And even in both the cases, it is a party-centric negotiation process wherein mediator and conciliator, both of them, facilitates the parties to negotiate among themselves and resolve the dispute. Coming to the approaches of mediation, so the mediation can take place pre-litigation, post-litigation, or it may be referred by. So that is where, even in case of conciliation, it can be pre-litigation or post-litigation. In case of pre-litigation, no law governs the private mediation, whereas in case of conciliation, in the pre-litigation governed by the Arbitration and Conciliation Act 1996, the provisions of this which we explained earlier. So in case of pre-litigation mediation, a mediation before approaching the court, mediation settlement agreement is enforceable as a contract in pre-litigation mediation. Whereas in case of conciliation, pre-litigation conciliation, it is governed by Arbitration and Conciliation Act of 1996, and without resorting to the court litigation, the settlement agreement is equivalent to the arbitral award on agreed terms and is likely a decree of a court as per section 30 of Arbitration and Conciliation Act 1996. Even though that is where the crux of the conciliation lies, that the pre-litigation conciliation settlement will also be binding on the parties, whereas in case of mediation, it will be enforceable as a contract. Coming to the post-litigation mediation and conciliation. In post-litigation mediation, the parties go for mediation on their own accord. The parties may withdraw the case after settlement. Even in case of conciliation, the parties go for conciliation on their own accord and the parties may withdraw the case after settlement. And with reference to the court-referred mediation, so under section 89 read with order 10 rule 1A of CPC, and that the court may refer the parties with the consent of the parties to mediation or to the conciliation. So this is about the approaches of mediation in case of pre-litigation, post-litigation, and court-annexed mediation and conciliation. So with this, we will move on to the further aspects of similarities and differentiation between mediation and conciliation. So in mediation is a facilitative role wherein The mediator assists the parties to identify issues, reduce the misunderstanding between the parties, clarifying the priorities among the parties, exploring the areas of compromise, generating options to solve the dispute. He doesn't generate the options, in fact, but he provides whatever the discussions that has been gathered from the parties, he plays it in a different manner that we call it as a paraphrasing or a rephrasing. So that paraphrasing or rephrasing has been discussed in the will be discussed in the future course of this course. Even the mediator emphasizes that it is the own responsibility of the parties for making decision which affect them and shall not impose any terms of settlement of the parties, wherein the mediator doesn't have any right to impose any terms of settlement, wherein the whole mediation process is voluntary in nature, wherein the party themselves negotiate among themselves and reach at an amicable settlement. Whereas in conciliation, the conciliator may provide options. The options adds to it is not only restricted to paraphrasing, but he may also provide the options to the parties. Mediation is not governed by statute. The court-referred mediation is regulated by mediation rules that has been framed by High Court, Supreme Court, and even now the mediation bill is there. Wherein conciliation, it is governed by Part 3 of Arbitration and Conciliation Act, that is from Section 61 to Section 81, which lays down the procedures, which lays down each and every aspect, how the conciliator is appointed, how the conciliation proceedings, what it should be, how should the communication take place between the parties. Those all things are been discussed in the Arbitration and Conciliation Act, that what we discussed in the earlier slides. So in both the cases, that is in mediation as well as in conciliation, when the court want to refer the case for conciliation, the mutual consent of the parties is must. The mediation, when the agreement is been drawn by the mediator and signed by the parties, it will be enforceable as a contract. In case of court-referred mediation, the mediator will frame the terms of settlement, and such settlement terms will report to the court and the court will pass the order. So that we call it as settlement decree under Order 23 Rule 3 of CPC. Whereas in case of conciliation, the settlement agreement drawn by the conciliator with the help of the parties, with the consent of the parties, that agreement will be enforceable as an arbitral award, and subsequently that arbitral award will be deemed as a court decree as per Section 30 of the Act. So these are certain differences, whereas there are various other challenges. Why? So what might be the challenges is like in a mediation, when we talk it as a voluntary process, so the party at any time they may quit the conciliation or mediation process. So in case how mediation and conciliation, so there are certain ups and downs in both the cases. That is, there are certain merits in mediation, there are certain merits in conciliation, there are certain demerits in conciliation, there are certain demerits in mediation as well. So mediation, coming to the mediation, it is being a voluntary process wherein the mediator only providing the role of facilitator and negotiating happens between the parties themselves. So that is a good idea to reach at an amicable settlement. Whereas in case of conciliation, the conciliator has to be very cautious while proposing the options, is because, and this is a great challenge for a conciliator, because if at all, if something wrong option that has been posed before a party and the party thinks that the conciliator is lenient towards the other party, then the party will quit the conciliation proceedings and walk off of the conciliation process. So these are the certain challenges which the conciliator, this is what the challenge in means of providing the options. And this is a demerit of a conciliation, whereas in mediation, the party or the mediator plays a role of facilitator, but even when paraphrasing, he has to be very cautious while paraphrasing as well. So these are the few merits and demerits of mediation and conciliation. Both the mediator and conciliator has to be very honest, integrity, impartial, neutral, unbiased, open. He has to be open-minded. He has to be very logical in thinking, and while paraphrasing, he has to be logically think and paraphrase. He has to be wide and understand the situation correctly and decide the right course of action. Maintain the confidentiality and transparency of the proceedings. Both the mediator and conciliator are required to go through that. So the expertise to understand the technicality of dispute, both the conciliator and mediator is required to have expertise among himself, like to understand the technicalities of the dispute. He has to be courteous. He has to act with the parties in a courtesy mind. He has to show respect to the parties. He has to be a good listener, because unless and until he's a good listener, he cannot be a mediator or cannot be a conciliator, because whatever the statements or whatever the say that has been put forth by the parties, the conciliator and mediator has to be keenly hear that and respond to the parties. Assess the interest and needs of the parties is very much necessary in order to formulate the terms of settlement. He has to be patient during the conducting of proceedings, have sympathy and empathy towards the parties, shift the focuses from the positions to interest. Basically, most of the parties during the anger, during the egoness, or being in a fear nature, their focus will be on their positions and not on the interest. And that is where the role of mediator and conciliator, being the facilitator for resolution of dispute, they should shift the focus of the parties towards the interest and not towards the position or towards the right which they have. But they should look after, they should think about the interest which they have in mind. Reduce the friction and diffuse any heated arguments. So this is all the role, the ethics of a mediator and conciliator. With this, we stop here, and in the next session, we will discuss on the difference between mediation and conciliation. Thank you.